Welcome to LevFin Insights podcast series, Levered Lines. I'm Luke Miller, Global Editor-in-Chief at LevFin Insights. I invite you to listen to our series of podcasts where we interview key market participants as we look across the main themes impacting the leveraged finance markets. And with that, over to the team.
Hello, everybody, and welcome to this special edition of LFI Levered Lines. In this episode, we're going to discuss the UK's premier restructuring tool, which the Part 26, a restructuring plan with a great panel of legal experts. The plan is in its sixth year of operation, but it certainly appears to have been suffering from some growing pains this year. Thanks to landmark rulings in cases we're all familiar with, it's been far from plain sailing, as acknowledged by many market commentators and most recently actually by Mr. Justice Leach himself. The big change came from the Court of Appeal in Thames Water and Petrofac, with a revised approach to the treatment of out-of-the-money creditors established by Virgin Active in 2021. This has raised some questions about how plans are put together and what will be a fair allocation of the benefits from the restructuring. There's been much soul-searching among practitioners and rumours of the rise of other restructuring options such as enforcement procedures. But to discuss where we are with Part 26A, how we got here and how they can evolve, we've got a great panel of experts. Tim Newey is a highly rated restructuring partner at Slaughter & May, who's worked on a number of plans, including the landmark Virgin Active case already mentioned, and one of the most recent ones for Poundland. We have Professor Sarah Paterson from the LSE, who is arguably the UK's leading restructuring and insolvency academic. She's also a senior consultant at Slaughter & May, where she practiced as a restructuring partner for many years. She's written extensively about RPs, and her opinion is widely sought. And we also have Ryan Perkins from South Square, one of the most sought-after restructuring counsel at the High Court, who's worked on many notable plans, including Adler, Virgin Active, McDermott, Aggregate, and indeed Poundland with Tim, I believe. So let's dive straight in. Ryan, you're kind of at the point of the spear in all of this. What's your assessment of where we are with restructuring plans and reflecting on the decisions that came down over the summer?
You used the phrase growing pains, and I think that's a good way of describing where we are. There have been a number of adverse recent decisions that have caused people to step back and wonder whether the tool actually works. I think that the tool does work, but there is going to need to be a significant change of approach, and the approach that was taken in cases from 2020 onwards of writing off sort of billion-dollar claims for $100,000 is not going to work anymore. Now, there are some scenarios where I think the restructuring plan can be used relatively straightforwardly. I think the restructuring plan is a really good way to compromise mass tort litigation or consumer redress claims, claims that are brought by large numbers of people with whom it's not very easy to negotiate individually. I think in that type of scenario, you can use a restructuring plan to cram down that sort of a class. I think you will need to carry out negotiations with a group of the affected creditors, possibly through a consumer advocate or a similar person. But I think the court will recognize the extreme difficulty of negotiating a bespoke deal with each member of a very large class like that. So the new approach that places heavy emphasis on negotiation doesn't seem to me to present a problem in that type of scenario. The scenario that is more difficult, and where I think restructuring plans do struggle, is the scenario that we saw in cases like McDermott, and more recently in cases like Petrofac, where you have a dissenting class consisting of one or two large creditors. There's a real issue about how you use restructuring plans to cram down those types of people. I think the reality is that the court's approach in the most recent authorities like Petrofac and Waldorf is to discourage the use of restructuring plans to impose deals on very small classes like that. Basically, the court's view is that if you can do it consensually, you should.
Thanks, Ryan. And Sarah, how are you feeling about where we are at the moment, Sarah?
So really interesting comments from Ryan. I think I have a few more reservations about mass tort, actually, but that might be for another day, where you're trying to cram a damages claim on a large mass tort class. I think that might be for a separate discussion. In terms of this idea around negotiation, I wonder whether we can just take a little bit of a step back to see where the negotiation idea comes from. And I think I'd be slightly more optimistic in that context about plans where you've got a small number of holdout creditors. So, I mean, as listeners will be aware, before the trio of the recent Court of Appeal cases that Ryan referred to, the jurisprudence had developed on an assumption that if a class wouldn't make a recovery in the relevant alternative, it was out of the money and it had no voice on the shape of the restructuring plan. But the particular feature, I think, was that an in-the-money class could decide to leave another out-of-the-money class with a valuable or contingent valuable right in the plan. So we saw plans in which one out-of-the-money class received a very slim return, didn't seem to be able to say anything about that, and another was left with potentially valuable rights. And that, I think that sort of got its high watermark, if you like, in CB&I when Mr. Justice Green said that there doesn't have to be any credible commercial reason offered by the secured creditor for the decision they've taken, effectively to leave value with one out-of-the-money class and cutting another out. So conceptually, that approach treats restructuring as a day of reckoning, in which the value of the firm's distributed down the distribution order of priority, but then with a kind of adjustment that the class in which the value breaks can decide to redistribute value to people at the bottom of the waterfall, skipping out intermediate classes. So I think when we think about negotiation, we also have to think about where this idea of negotiation comes from. I think the courts have been very clear that there isn't an absolute duty to negotiate in all circumstances. And I think Ryan's point around perhaps there being more pressure on that with a small number of creditors where you could have engaged, I think that's where it's really well taken. But I think it's important to remember that the negotiation point comes from really a different conceptual approach to what it is we're doing. And I would argue it's an analysis that really focuses more on the core jurisdictional concept of a compromise or an arrangement. So not this idea of distributing firm value down a waterfall, but rather the idea of a deal around sharing sort of potential future upside. So in Petrofac, the Court of Appeal told us that the proper use of the cross-class cram-down power is to enable a plan to be sanctioned against the opposition of those unreasonably holding out for a better deal. So in other words, the company's got to try to secure a compromise or arrangement with each impaired class. And it's only if a class is unreasonably refusing a fair offer that the cross-class cram-down power can be invoked. I don't think that always means you need to negotiate, but it does mean that there needs to have been a fair offer. And crucially, that rests, I think, on a different conceptual understanding of the cram-down power. The question isn't whether firm value is sufficient to repay the creditors who are crystallizing a loss, but rather how creditors should be compensated for writing down their claims so that other creditors and potentially shareholders who are staying in the game and avoiding an insolvency and a crystallization have a shot at making a greater recovery. And I think that's quite a different idea. So sort of pulling all of that together, the power exists really to address strategic behavior. So hold out, hold up, and free rider behavior, or just misjudgment, a class thinking that the situation is better than it is. What it doesn't exist to do is to deny a class of creditors that is crystallizing a loss any chance of sharing in a gain that their concession has facilitated for other people. And so I would be a bit more optimistic that if you had a small number of creditors, but they were unreasonably holding out and you didn't seem to be making any progress in achieving a deal with them, and you genuinely felt that you'd made them a perfectly fair offer, I would be much more optimistic that the cram-down power could be used in those circumstances. What you can't do, in effect, is just say, well, they have no share in the gain. I don't have to think about them at all. I'm going to pass immediately to the cram-down power and avoid everything else on the journey.
Great, thank you for that. Tim, you were involved in Virgin Active on the first big plans in 21, and Poundland, one of the most recent, which came after the decision came after the big summer rulings. So how do you feel that the whole process worked from that that later plan versus the first one?
I think Poundland is a good example of what Sarah was just saying. So I kind of think that going forwards, there's going to be an increasing emphasis on being able to kind of explain the approach that you've taken.
Mm-hmm.
And so I think that is both explaining what you've put forward and why it's a fair proposal. So I think, as both kind of Sarah and Ryan have said, you can't, gone are the days in which we've seen in some of the more recent plans where you effectively say, this class are out of the money and therefore I'm going to give them slightly more than zero, and that's kind of good enough. I think you need to be engaging going forwards with why what you're putting forward is a fair proposal, and that might be by reference to comparators, that might be by reference to what is the costs of doing it by another mean, and are we reallocating those costs to the unsecured or holdout creditor in a kind of fair way. And I think that will vary depending on the position of the other creditors. So if you've got a plan where equity is retaining its shares, then I think the way that you treat unsecured creditors is likely to be different than if it's a scenario where the secured creditors are taking the equity effectively and shareholders being cut out. So I think you kind of have to engage with all of those issues and put forward an explanation to the court as to why you came up with what you're doing. And then I think the second bit of that explanation is around the kind of process that you've run. So I think you need to, going forwards, plan companies are going to need to sort of run a process or be able to explain why they didn't run the process, or to explain the process they ran or why they didn't do one, they did one thing but not another thing, in terms of the way that they sought to negotiate with other parties. So I think Poundland is quite a good example because it shows that isn't an absolute requirement to negotiate before a plan is launched, and that the court will be flexible on that. So that was one where there were a huge number of landlords that would be very difficult to negotiate with bilaterally, or even in a kind of group where you were able to negotiate with a significant proportion of the landlords. But also the plan was being developed against the backdrop of a sale, and with Pepco, the seller, being a public company. And so there the court said, no, we understand that you couldn't negotiate with all of the landlords in advance of launching the PSL. And he put a lot of weight in the fact that Poundland, once they had launched the PSL, did run a kind of extensive process to seek to engage with landlords, and did adjust the terms of the plan for landlords following the convening hearing and following dialogue with landlords. So I think that's a good example of it's a kind of comply or explain type of scenario where the court's going to expect you to kind of engage with the issues both on the substance and the process, and to be be able to explain the approach you've taken, and what, in cases where you haven't been able to negotiate, why you haven't been able to do that.
In the recent cases, there's obviously been a huge emphasis on the fairness of the process and the procedure. How do you think the courts in recent cases, and particularly with regard to the new practice statement, have clarified what is expected now of parties to these plans? Ryan, is it much clearer now what people have to do?
I think it's reasonably clear what you should do in cases involving a class, often an out-of-the-money class, but not necessarily, with a large and potentially unworkable number of creditors. Landlords are a very good example. If you have 100 landlords, there's no way you can do a consensual deal with each and every one of them. It's just too difficult. And I think that you should have a town hall meeting or something like that. That's one of the things that we did in one of the recent landlord cram-downs. There should be some level of outreach and engagement. And as I say, I mean, some people have reservations. I think Sarah has reservations about using these types of structures for cramming down mass tort claimants, but I don't. And in principle, I think that there are ways that you can set up a proper process and negotiation with those types of creditors. As to the more difficult question of how you deal with one or two creditors that you can negotiate with who hold big claims, the jury is still out on exactly what it is that you need to do. I'll give you a concrete example. Suppose that there is a creditor with a claim of $1 billion, but it's unsecured and it may be out of the money in the relevant alternative or heavily underwater. I don't think it particularly matters for the purposes of this example, but it's a large unsecured claim. Now, the purpose of the restructuring plan is to restructure the business and to put it on a sound footing for the future. And as Sarah put it, the restructuring will generate a lot of value for other people. The secured creditors will do well out of this deal. In a formal insolvency scenario or a liquidation, the returns would be bad, potentially catastrophic, but let's just say bad for present purposes. The secured creditors in the company approach the large unsecured creditor and they say, we'll pay you 5p in the pound in cash. And the unsecured creditor says, no, that's not right. You're going to be making a lot of money out of this restructuring. I want 50p in the pound. And the company says, all right, we'll come up a bit. And the secured creditors grit their teeth and they write letters saying this is as far as they'll go. And they say, our best and final offer is 15p in the pound or 15 cents in the dollar. And the unsecured creditor says, I'm sorry, we just can't do that. We're willing to reduce our offer to 25p in the pound, 25 cents in the dollar, but we can't go any further. And so the company then applies to cram down that class. What I think we're missing at the moment in the case law, and I'm sure that this question will be answered in due course, is how is it? On what basis exactly does the court decide whether the creditor in that situation is being unreasonable? How does the court know whether an out of the money or very heavily underwater creditor should get 15p in the pound or 25p in the pound? If the question is who is acting unreasonably, what are the relevant standards of reasonableness? And I think that's the question that needs to be dealt with in the case law, because at present, the answer is not entirely clear, at least to me.
Would they want to see evidence of communication between the parties?
Oh yeah, but there's always communications in these cases, even in Waldorf. I mean, there will be, and nowadays, given what has been said in the case law, one can rest assured that there will be very heavily choreographed correspondence with all dissenting classes that will be carefully recorded and available to the court to see. So that will all be available, but the court will still be faced with a decision, and I think that's where we need further clarity.
Tim, what's your feeling about the practice statement? It feels like much more work will be needed to get done before the case comes to court. Do you think people are clearer now on what's needed in terms of evidence and that kind of thing?
Yeah, evidence is a really interesting question, I think. We saw on the recent, a couple of recent plans, this concept of a restructuring benefits report, which I think in one case was quite well received by the judge, but then in the Poundland case that Ryan and I were involved in, I think the judge, the judge sort of thanked the plan company for it, but concluded that it wasn't necessarily of much use to it. I think it's pretty difficult in a lot of cases to sort of reduce what's happening to some numbers on a page. So for example, in that case, one of the things that's difficult is if you have a landlord writing off some out of the money debt, how do you compare that to a party who is putting in new money, and what relative weighting do you give to those two? So I think the restructuring benefits report is something that is likely to evolve over time and may have use in some cases, more use in some cases than in others. I mean, I think other things where we sort of started to see, and will be interesting to see where they continue. So in Thames, you had, I think, the Class A creditors, FA, kind of giving evidence and explaining why the deal had got to where it was, and why the Class A creditors wouldn't go any further. And I expect that creditor advisors may be taking the stand more often going forwards for that kind of reason. I think where you can't reduce something to numbers, whether there is a space for more of a kind of reasonableness or fairness type opinion. So maybe you appoint an independent expert who sort of, looks at on one side of the ledger what each creditor is giving up, and on the other side of the ledger what they're getting through the plan, and sort of looks through that and says, does this seem reasonable? Is anyone getting too good a deal? Is anyone not getting a good enough deal? and gives more of a sort of subjective, sort of more of a qualitative view on the outcome. I think that's the kind of thing we might start to see more of. But you're right. I mean, I think evidence, particularly following Petrofac, there's a sort of increased focus on what do you need to evidence. And I think people are going to be very focused on evidencing pricing of new money going forwards. But I do think, I think there needs to be a bit of a balance, because we need the plan to be an accessible tool, especially for more sort of mid-market companies. And so there does need to be a balance. And I think there's a bit of probably a responsibility on judges to think, what kind of to steer companies as to what evidence is needed in particular cases, and also on practitioners to think what are the key things that need evidencing in this case, and focusing on those rather than having sort of every possible piece of evidence. Because while I think that it's nice going to court with every piece of evidence, it sort of does make the process a bit unmanageable and expensive.
So I think you have fairly strong views on the value of the valuation evidence.
I do, but actually, before we get there, Matt, I wonder if I can just go back to Ryan's example. I have strong views on everything, as you all know. So I think if the cram down rule is doing its job, Ryan's example is quite unlikely, because a good cram down rule distributes bargaining power so that no one is really incentivized to resort to it unless they have to. So if our gap is between 15p and 25p, each side has to decide whether it wants to roll the dice on the cram down rule. The problem, if you like, with the out of the money approach was that it distributed bargaining power absolutely solely to the secured creditor. I mean, it incentivized, or wherever the fulcrum class was. So it incentivized whoever that fulcrum class was to go straight to cram down. There was virtually no incentive to attempt any sort of consensual deal at all. And in my world, we always want markets to try and solve these problems if we can. The people who really know what is a sort of reasonable share are actually the actors themselves. And we should in my world, we should put a premium on that. And in its heyday, Chapter 11 really did. So if we get this right, the unsecured creditor in Ryan's example, if they've already got 15p on the table, they take really serious costs, risk, and a challenge. They've got to, and this is very different from Chapter 11, where the Unsecured Creditors Committee has its costs paid. And I cannot emphasize enough what an important point this is. In the UK, the unsecured creditor takes quite a serious costs challenge. They at least have to pay their own costs, and those are not going to be trivial. And they stand relatively little prospect of getting those back from the company. And we've also seen that in the 15 to 25p example, if the court decides that in fact they have been unreasonable and they haven't assisted the court, there's a risk of an adverse cost order, and there's even a risk of indemnity costs. So that is a really serious incentive for the Unsecured Creditors Committee, the unsecured creditor in Ryan's example, to be thinking about that 15p offer. Similarly, those who are, standing to make this massive benefit from the restructuring, and for whom the return in the insolvency is, really not very good, they have a serious incentive to check that they really can't go above 15p and closer to 25. And so if this is doing its job, it's a credible threat. And I think we'll come on later to why I really think it is. Its flexibility makes it a highly credible threat. I think a much more credible threat than restructuring plans in many other jurisdictions. But if it's doing its job, it exists as a credible threat for everyone to redistribute bargaining power to make it much more likely to that 15 to 25p gets closed. And in the end, that's what we want markets to do. This tool exists to solve the frictions in markets, not, in my world, to replace the market mechanism. Ideally, the actors sensibly decide how to share a gain, which is going to make everybody better off. So that's on the sort of the bargaining dynamics. On the evidence, I have incredibly strong views. So we decided one possibility would have been to adopt the US approach to fairness. So the US have worried for a long time about this risk of washing off an intermediate class and have moved steadily over time to a very strict absolute priority rule, as I'm sure listeners will know. So it becomes very, very difficult to achieve what we were achieving in our early plans, where shareholders retain shares, but an intermediate class is washed off. But they also take very seriously the risk that the senior class gets too good a deal. That they wash off the junior liability, and then the firm returns, once it's got rid of its massive tort liability, in Ryan's example, it returns to fabulous profitability, and they make a massively outsized return. And the way that the US deal with that is that they do run a value down the distributional order of priority, but they require it to be effectively a fair market value, not the current market price for the firm. So, what would a willing buyer and a willing seller pay in normal market conditions without the taint of bankruptcy? Now, the problem with that is it's pretty much a fiction. Who the heck knows? There is no way of knowing that. And so that has led, where there is a cross-class cram-down fight, to an incredibly costly valuation fight with incredibly costly reports that have the veneer of looking scientific, but which are in fact not very scientific at all. And I think when we were consulting them on this in the early days, we knew that we didn't want to go route. We didn't want to create the deadweight costs of that sort of evidential burden. And my concern is that we are at risk of recreating that through some of the evidential reports that we now seem to be requiring, in exactly the same way that we cannot really know what the fair market value is, and it's famously described in the US as a guess compounded by an estimate. We can't really know what the future, we can't know what the future performance of this firm that's just been through a restructuring is going to be, and somehow put some sort of mathematical precision around the market exercise, which should just be us negotiating towards what we think is a fair share of the upside that we're going to create by cooperating together to do this deal. And so I'm really opposed to building very expensive evidential burdens that I think sort of look superficially attractive, but in fact, really add very little to the debate. And I'm as concerned with that, frankly, in the large company space as I am with small and medium-sized companies.
Okay. You mentioned some of the considerations faced by Chapter 11 in the US. In terms of the restructuring plan, as we just look briefly under the hood a little bit more, what are the risks of the negative perceptions that might be limiting its use? I mean, activity's definitely dropped off in the second half of this year. Are people looking at other options, other tools at the moment? Tim, do you have a sense about this?
Yeah, I'm sure that's the case, but I think that was the case, before Petrofac. I think it was the case before we had the RPs, and I think it will continue to be the case. Mm-hmm. Benchmarking has always been a feature of these kind of complex restructurings, and there are other new mechanisms that can be used in other jurisdictions as well. So we're kind of not alone in having this new procedure. I mean, we've certainly seen that in even for some kind of English holding companies, we've ended up using Chapter 11 twinned with a pre-pack administration. So I think that's the kind of these are the routes, and I think that people are going to continue to consider. I think this is sort of what Sarah was sort of starting to hint at in a minute or two ago. I think there remain a lot of attractions to an RP as compared to some of the other options, and I think actually those have been quite well evidenced by recent cases. So the Poundland one, which I've mentioned already, is a good example of the shareholders being able to retain equity even where unsecured creditors were being considerably written down, and that's not something that you'd necessarily be able to do in Chapter 11 or another process. And then similarly, we've had the US headquartered fossil case coming to the UK from the US because of the greater flexibility offered by the RP. So I think the RP remains an incredibly kind of flexible and powerful tool, and I think it will continue to be used, even if people are benchmarking against against other options, and that will be other options, other processes, but also things like, there's a lot of chat obviously about LME. So I think people will be benchmarking LME versus, completing restructurings through restructuring processes. But you can achieve a much more, a much deeper restructuring through a restructuring plan than you're ever going to be able to do through an LME. So I think there's suddenly reasons to ask these questions, but I think there's also cause for significant optimism as well in terms of the process that we have.
Yeah, Ryan, some other commentators have been a bit more negative about what's happened this year for RPs. Sort of where are you? Are they going to be? Is there a risk of them being sort of displaced, or are you being sort of pointed elsewhere in terms of restructuring tools, other jurisdictions?
It's an interesting question. I'm not as negative as some people are. In fact, not even as close to as negative as some people are. I think my perspective is this. Restructuring plans are expensive. They're too expensive in part because of the excess of valuation evidence and other evidence, some of which the court has required, such as market testing evidence in relation to new money. So they are too expensive for that reason. But even if the evidence is simplified, which it should be, restructuring plans are still expensive, and they shouldn't be used in every case. I mean, where there is a straightforward securities enforcement that can be done, that should be done. There's no reason why you should approach the court if you can do a security enforcement. Mm-hmm. What I think is less likely is that the restructuring plan will be displaced by the WOA in the Netherlands or Chapter 11 in the US. In fact, I see no evidence whatsoever of that. And those processes have their own difficulties and their own constraints. As Tim mentioned a minute ago, the private equity sponsors of distressed companies can retain a substantial part of their equity through a restructuring plan, which is something that would induce horror in many bankruptcy judges in the US. And the slight vagueness as to the test for cram down is also one of the biggest advantages of the structure, because it's flexible and there are no hard and fast rules. So on the one hand, you have some uncertainty. It is difficult to cram down small classes with highly motivated challengers who just are being awkward. That is difficult. There's no doubt about it. But on the other hand, you're not faced with strict rules like the absolute priority rule that stifle you from the outset. It's a kind of constructive ambiguity. And so I think it's wrong for people to suggest that restructuring plans are dead. I just think they need to be used in the right cases. And I think that the negotiation and consultation process has to be very carefully choreographed so that the court has some degree of sympathy with the company when it turns up and asks to cram down a very substantial class of creditors. But I do think that the supposed death of the restructuring plan has been exaggerated. I also think that there hasn't been a fully litigated challenge to an LME or out of court restructuring since really Assenagon in 2013. And there are and there will be challenges to transactions like that where distressed disposals are carried out under intercreditor agreements. I mean, at the moment, what we have is this massive litigation on Part 26A, which seems to create lots of uncertainty, and it does create some uncertainty. And then on the other hand, we have no reported judgments concerning LME matters or out of court restructurings, and so it looks very lopsided. And if you're a hedge fund and you're thinking about which process to do, the LME approach looks very attractive, and in some cases it is. But I suppose the best way to put it is this: one should not assume that the case law will look like that for long, and challenges to out of court restructurings could end up being just as common and just as difficult to deal with as challenges to restructuring plans.
Yeah, thanks, Ryan. Fossil plan, that definitely appears to have been a bit of a shot in the arm for Part 26A as the year drew to a close. I think I'm right in saying it's the first time a US public company has gone outside the US to restructure US government debt, maintaining its share listing. Sarah, I think other that seems to highlight that, RPs can be very, very flexible and, possibly become a gold standard if they can allow companies to target particular tranches of debt, without impairing equity. Then that's a good option, isn't it, for some companies?
Yeah, I think it's really important that we don't lose sight in the international conversation of just what a unique tool we've got here. We can do things that you cannot do with other tools, and they've been mentioned by both Tim and Ryan, but now within a framework that also has, takes fairness writ broadly seriously. So we can now, I think, articulate what the tool does. We can articulate why it is okay to leave shares with with the shareholders in circumstances where out of the money creditors are not being paid in full. We can articulate why we adopt that approach. It's not simply that the secured creditors can decide what to do with the value. It is to do with relative contribution. And if the shareholders are providing the post-restructuring strategic governance and they need to be incentivized to do that, then the fact they get the bulk of the equity makes perfect sense. I mean, that part of the reason that Chapter 11 doesn't do that is that it was created in an environment that assumed large public companies with dispersed passive shareholders, so that the circumstances in which shareholders would need to keep equity in order to be incentivized to turn the business around on the other side really only apply to small owner-managed businesses. In the modern world, it's as likely to apply to a large private company as a small owner-managed business. And we are in a happy position of building a tool in 2025 that responds to modern markets. We are not simply replicating old technology, but thinking about how that tool should work in the modern world. And I think we do the tool a really serious disservice if in the conversation we don't make clear the things that it can do that are really quite unique. I also don't think that the fact that we're seeing a rise of out of court restructurings is in itself surprising or a sign that the plan isn't working. In fact, it may mean exactly the opposite. It may mean that the tool's matured and that it's started to do its job. So in the early days of Chapter 11, there were a large number of non-consensual cram down plans. But then those gradually disappeared as the expense of the valuation fight became clear, but also its uncertainty. And there was a massive shift towards more out-of-court deals. I would suggest the reason that isn't really happening now is because Chapter 11 doesn't really create the right threat point. It's got to be credible that parties would resort to it if they needed to. But that is exactly what we saw. And so if we have a tool that can be used to motivate those out-of-court deals, and where it is the tool that companies are using to motivate bargaining, then it may very well be doing its job, even if we see fewer contested cram-down hearings. There is an entirely separate question about the nature of the out-of-court restructurings that are then happening. And Ryan and Tim have both alluded to that. So it is a separate question about whether an out-of-court restructuring that takes the form of a non-pari LME raises its own challenges, and whether if parties are resorting to that as the out-of-court solution, that raises different issues. I'm sure that it does. I suspect that's one for a future podcast and not for today.
No, there are definitely grounds for optimism. I think the practice statement has got to help, because, as Justin Leach said in a recent speech, it will make everyone kind of put their cards on the table beforehand at a much earlier stage in the process, which should make identify issues far in advance than they have been up until now, and hopefully just make the whole process a lot smoother. But in terms of specific improvements, are there any that you particularly want to see, Sarah, just from your perspective?
Yeah, I think that the problem that we now have is that the restructuring plan, because it's based on the scheme of arrangement, which is really just an implementation tool. So the scheme of arrangement based on the idea that the majority support the plan, and the minority shouldn't be entitled to hold that up. It's based on a principle of majority rule. And so unless there's reason to doubt the motives of the majority, that's a plan that should be implemented. What's really clear to me now is if you stick cross-class cram down on the bottom of that, you make a completely different thing. Because by definition, cross-class cram down can't be about implementing the deal that you've done. And so I think what we are struggling with is using the RP to create the structured bargaining framework within which the deal can be done. And the particular problem, it seems to me, and Ryan will know this much better than I, but I think the particular problem in this is that often the commercial tension will only really be created on the courtroom steps. So what the RP doesn't really do is provide an environment within which you can carry on negotiating and then use the tension of the RP and the upcoming hearing, or even the response of the court in the hearing, to finally close the deal. So Ryan's 15-25p gap, to try to drive us to 19p or something at the end. And I think both Ryan and Tim will have much more to say about this than I do, but I think the two specific things are the ability to make modifications. I don't think, I'm a little bit gloomy about the prospect of new legislation. I think we need to try and work with what we've got. And after all, leave to convene, the convening hearing was an entirely court-created process. It doesn't come from the legislation. And it arose from a very similar problem in schemes of arrangement, a concern that you would get all the way to the end, only to be told you hadn't constituted your classes properly. And we ended up in a very similar sort of space where people didn't want to do schemes of arrangement because there wasn't much case law on classes and how to constitute them. And then because no one was doing them, that case law wasn't emerging. And the practical response was through the practice statement to develop the convening hearing. I think we need to think about that too. Is there a process for adjourning the sanction hearing, for example? Is there a way of reholding the vote very rapidly without requiring everybody to start all over again at the beginning? So I think that whole modification piece is hugely important. And then the second question, of course, is the moratorium. I'm not going to say much about that. I think every listener will know I've been on a one-woman campaign to say administration is not as hopeless as everybody thinks it is. I think it just has terrible PR. I think it's actually really quite an effective tool if you've got a large business and you need to hold it stable and create liquidity whilst you try to do a deal because the situation is deteriorating very fast. But I have to say, even I am becoming a little bit despondent that anyone will ever join me in thinking that that's a sensible answer. The Part A1 moratorium undoubtedly suffers from major problems. Again, I think the difficulty is that it seems to me that legislative change around a moratorium, if it comes, it isn't going to come quickly. But that's the second piece I think that we probably need to think about.
Ryan, how about you? What improvements would you like to see?
So I agree with all of Sarah's points. Just taking them in reverse order. On the moratorium, I think the best moratorium is an informal judge-made one, which is when the court just says, there's a restructuring plan that's been proposed, or there's a scheme that's been proposed. Why are you here? What do you want? And that started in Vietnam shipbuilding. We got a similar order in Virgin Active. I actually really like this, and I think there's a way of expanding it as well. So I to be honest, that line of authority is something that I've found in practice, which has prevented probably thousands of creditor actions because they're advised that trying to do some sort of court action while a restructuring plan is pending isn't going to work. Now that only takes you so far because it's not nearly as broad as the administration moratorium. And I agree with Sarah that administration is still a useful procedure. But I'm bullish that the court can produce informal moratorium-like effects, and in fact has already done so. On the question of modification, this is incredibly important. One cannot have a procedure which is ostensibly designed for collective bargaining or which is in some way based on negotiation if the deal that is launched in the PSL has to be the deal that is sanctioned at the end. That just doesn't work. And the court now appreciates this. But nonetheless, there are some bad judgments which suggest that modifications might be problematical. And I think there are a couple of judicial innovations that will be deployed and need to be deployed. I agree with Sarah that primary legislation is something I'm not optimistic about. So the first thing that needs to happen is that the court needs to understand the proper juridical basis for modifications. In the 19th century, there are actually quite a lot of cases on modifications. They're incorrectly viewed as a kind of change to the plan, but in many cases they're not. A lot of the time, instead of talking about modifying the plan, it might be more helpful to think about the company undertaking to do something in the event that the plan is sanctioned. That's actually how modifications were rationalized in the early 19th century cases on the subject. But secondly, I think that people need to get a bit clever about how they structure proxy forms, so that, for example, votes can be valid at subsequent meetings that might need to be convened on short notice. I think that that the court needs to be flexible on the timing of reconvened plan meetings in order to consider a new deal. There are ways that those can be done very, very quickly. Creditors who have any interest in the process should register for a website of some kind so that they can get communications very quickly. And they should be expected to vote on revised plans within a few days. That needs to become something that is standard. And once one has the ability to have very fast subsequent meetings or reconvene meetings, which the court helps to facilitate. And once one also has proper recognition of the fact that modifications have been done since the very beginning of Part 26, you can end up with a procedure that looks more well-suited to a dynamic bargaining process rather than a static deal that remains the same from start to finish. So I think all of that is important. I think it's really for the court and for practitioners to sort this out. I think the idea of parliamentary time being spent on this is a little fanciful.
Yeah, no, that's great advice. And Tim, just any thoughts on you about what you'd like to perhaps see done differently?
Just picking up on what Ryan said, I mean, I think to be fair to the judiciary, they are starting to show that kind of flexibility. So, in terms of reconvening creditor meetings on short notice, I think that happened in the aggregate RP where the plan was modified and then the plan company held another meeting quite quickly after that. And as Ryan says, we've also seen some flexibility, albeit I think the jurisprudence is a bit inconsistent on ability to to amend plans or have kind of side deals even as the plan progresses. And I think getting sort of further clarity from the court on how that's expected to work will be helpful. I mean, I think one thing that would sort of help with all of this, I suspect, is if a judge is sort of assigned to a case from the outset and stays with it throughout, because it's quite common that you have a different judge for the convening and the sanction hearing, and actually they're interested in different things. If you had a judge who is assigned at the outset and they're sort of responsible for time periods, when the convening hearing's held, sanction hearing, ideas like adjourned sanction hearings, etc. I think that would be beneficial. And as part of that, you hear talk of potentially having CMCs or judges encouraging experts to have meetings to narrow issues in advance of hearings. I think all of that is likely to be pretty useful in some cases. But I think it relies a bit more on there being a judge, like with a kind of piece of commercial litigation, who kind of takes responsibility for the case and the running of it from the start. And then I guess just as a second thing that I think, and it's sort of rounding back up to what Ryan was saying, he was saying in a couple of years we might have a few kind of negative cases on out of court restructuring routes that make us think differently about those. I think we're also going to feel different about the RP when we have a few kind of big RP financial restructuring cases. Post Petrofac, I think the cases that we have had have probably been not quite of that nature yet. But if we're sitting here in a year's time and we've had some really big and financial restructurings that have gone through and the RP has performed well as kind of resolving those matters, then I think we'll feel kind of much more confident about what we need to do. And actually, I guess to Ryan's 1525p issue, the more cases we have, the more those you're going to be able to look at what's happened in the previous case and sort of have some guidance from the court on what's likely to be acceptable. So I think that there are definitely things that I think we're kind of agreeing it comes down to the judiciary to try to improve, but I think also just more time and more cases is going to allow the procedure to develop as well.
Yeah, that's been really interesting. Just before we wrap up, just looking at the time, can I put you all on the spot briefly, just to ask, what one tip would you give a plan company expecting some opposition to what it's about to propose or going to propose. Can you think of anything off the top of your head that you would advise a company to do in this new environment? Ryan?
Well, I think they need to have the most carefully choreographed and documented negotiation that they can possibly have with each potentially dissenting class, something that can be evidenced and shown to a judge. I would also advise that companies, and perhaps more importantly, secured creditors who often call the shots, need to be flexible. And the idea that they're going to turn up with a deal that is opposed and then not move and stick to their guns should just be dismissed at the outset. It should be a bargaining process that is not dissimilar to what one might do when buying a house. You don't put your best foot forward at the beginning, and you absolutely do not expect that your first offer will be the last. And if you can set expectations in that way and document carefully what you have done to engage, then I think you'll find that you're in a very different world from the unfortunate situations that arose in some of the recent cases.
Yeah, well, when I bought my house, my first offer was my last, so that probably shows you. But no, Sarah, that must be music to your ears, what Ryan has said.
Yes, and my tip would be not to just concentrate on what you're offering and why you're offering it, but to hold the feet of the dissent to the fire and demand that they explain what they want instead and in terms, not vaguely. So in Ryan's 15 to 25p example that we're all now adopting, why won't you accept 15p, and that they justify it? Because I think that there's been a great deal of focus on objecting to the offer, but in some of the cases, not enough focus on what the dissent want instead. And I think when the court has both of those things in front of them, so what was offered and the justification for it, but what you want instead and what the justification for it is, I think that will do a good job in closing gaps and potentially leading to sort of, in some cases, I suspect, last minute deals.
And Tim, finally, from you.
I'm in the unfortunate position of going last, so Ryan's already stolen my one. But I think kind of as an extrapolation of that, I think there's sort of the plan company. There's sort of a bit of a shift in mentality from kind of how do I get this deal through to almost like a sort of honest broker between the different parties. And I think that goes to Ryan's point about setting up kind of a negotiation. And I think there are different ways, sort of different things or different techniques will become will develop as to how they manage that. And now in some cases it might be mediation is something that's been talked about. So maybe have a mediation to try and resolve issues. But I think actually the company can kind of, in many cases, may be able to perform that role without the kind of additional costs of mediation. So going between, jockeying between different creditors, and even maybe, getting everyone, it's a bit old fashioned now, getting everyone into a law firm's offices and having a series, everyone in different breakout rooms, and the plan company going between them and trying to broker a kind of solution. I think, going back to what Ryan's saying, if you then present that you've done that to the court, I think that's and even if it's failed, but you've attempted to do that, I think that's going to put you in good stead for seeking to apply cram down.
And on that point, Tim, I mean, one of my favorite recent examples that people often forget about concerns the treatment of the FSMA claimants in Petrofac. So everyone remembers Petrofac for being the case which was sanctioned at first instance and failed on appeal. But there was actually a brilliant bit of judicial negotiation, if I can describe it in that way, at first instance concerning the FSMA claimants. So what happened was that the company turned up and said that it wanted to get rid of a lot of redress claims brought by current or former shareholders for very, very little money by way of compromise. I think it was another one of those $1 million to write off $1 billion of claims type arrangements. And the judge saw it. It was Mr. Justice Marcus Smith at the convening hearing, and he said, "I feel a bit queasy about this. Are you sure this is a good idea?" And this was actually before Virgin Active had been overruled. But he said, "I'm not sure about this." So he strongly encouraged the company to appoint a consumer advocate and to go off and negotiate with 3 of the main claimant law firms who were acting for the FSMA claimants. And he said, you might want to think quite carefully about your deal, because I'm not really very comfortable with it myself. Have you considered giving them some equity? So the parties went away and did what Tim just described, that people met up at law firms. There wasn't some sort of pretentious mediation. It was just a simple negotiation. And in the end, that class, which was going to be the main dissenting class, that case started off being all about the FSMA claimants, ended up doing a deal that involved some additional cash, but most importantly, some warrants divided into 2 tranches, which could end up being non-trivially valuable. And the value of that consideration was very less than the $1 billion of claims, but it was still non-trivial. And then there was time to implement that modification to the plan. A revised plan document was circulated before the plan meetings, and the judge was comfortable with that. And there was no need for a cram down. And I mean, just describing that, I think gives one more confidence in the process, because that's how it should look. It shouldn't be a big disaster at sanction where there's a shock because the judge says there hasn't been enough negotiation and the company hasn't done its job of moving from party to party to try and reach a deal. So it's an example that I like to give to people of how the process can work.
Mm-hmm. Yeah, no, that's great. Thank you very much, Ryan. That's been a really interesting discussion. It's pretty clear that the RP is a very useful tool for contingency planning and for implementation in a wide range of scenarios, given its unique flexibility. That's definitely been demonstrated by Fossil Group, and it sounds like that could be followed by a much bigger US company coming across the Atlantic. We'll have to see, but it's clearly going to be very important to show that a fair process has been followed and to justify the allocation of whatever is proposed. So it'll be interesting to see how this happens in practice. Hopefully, we can reconvene in a year's time also to see how it's all going, and I shall look forward to that.
And to see how the LME transactions are going as well. Because, I mean, what I would say about LMEs, just by way of conclusion on this, is, I mean, I love them. I advise on them all the time. And I think that you can have some very inventive structures that work. But I would say it's all fun and games until your restructuring gets set aside 3 years down the line and you find that you failed to release $1 billion of debt that you thought you had got rid of. It's a bit like the difference between seeking tax clearance up front, which can be really painful but necessary, and putting in place a structure which is challenged years later. It's a bit like that, and it's wrong to think that putting all of the risk into the tail end is always the way forward.
Thank you very much. Thanks a lot, everybody. I appreciate your patience for this.
This podcast should not be copied, distributed, or reproduced in whole or in part. Neither LevFin Insights nor its affiliates makes any representation or warranty as to the accuracy or completeness of any information contained in this podcast. LevFin Insights is not providing investment, legal, accounting, or tax advice. LevFin Insights is not providing research or making any recommendations, nor is LevFin Insights offering or soliciting any transaction with respect to the purchase or sale of any security that the listener may hold.